Ladies and gentlemen, as I recall, the first time that I learned from this evidence that the defendant's story, which you heard many times both on the direct case and the defendant's case as to what happened on the 16th and the 17th, came sometime after 4 o'clock that morning when Sergeant Tevere, Kenneth Micah, and other MPs came to the MacDonald house for the first time to respond to what they heard on the radio was a medical emergency. Recall that Tevere and Micah, the government's first two witnesses in this case, who heard the defendant say something like this in the master bedroom, there were 4 intruders, and he described them. There were 3 males, 2 of them white, 1 of them black, wearing a fatigue jacket with E6 sergeant stripes on one of the sleeves. The girl, as Tevere and Micah stated, as I recall their testimony, had on white muddy boots. She had a floppy hat. She had long blonde-like hair. He thought she was carrying a candle, and these 4 people tried to kill his family and left only him alive. Shortly after 4 o'clock, he went to the hospital. About 4 hours later, his family went to the hospital, but unfortunately, at about 9:30, rather than responding to additional medical treatment, Colette, Kimberly, and Kristen were autopsied. Now, for just a few minutes, I want to go through again a rather unpleasant task, and that is to examine again the injuries sustained by all 4 people in that house. Let's take first Colette MacDonald. You will recall the testimony of Dr. George Gamble, who performed the autopsy on Colette MacDonald. What were the injuries that she sustained? First of all, he testified that she had 2 broken arms. I think the right arm was broken in both bones. And as I recall the testimony, the left arm was broken, and one of the bones was broken in 2 different places. In his opinion, those were in the nature of defensive wounds and were, perhaps, some of the first wounds that she received and could have been caused by the club. Now she also received, as you recall, between 6 and 8 lacerations, 1 to the chin, as I recall, down here, indicating, several to the head, breaking the skin and in the middle of her head, fracturing the skull. She received numerous wounds that, in his opinion, were inflicted with a single blade sharp knife that could have been done by the old hickory knife that, as you recall Paul Stombaugh's testimony, was sharp, and you recall Bob Shaw's testimony was found at the MacDonald house outside the back door of the utility room. About 16 or 17 cuts she received. As I recall, 9 in the neck and 7 in the chest. In the chest, her pulmonary artery was cut or hit. Her lungs were punctured. Her trachea was hit at least twice. Colette MacDonald died, according to Dr. George Gamble, simply bleeding to death. She also received 24 puncture wounds that were consistent with the ice pick and could have been made by that ice pick, according to the testimony of Dr. Gamble. That also, if you recall the testimony of Bob Shaw, was found outside the utility room door. Now, ladies and gentlemen, 3 of those ice pick holes we submit were on the left arm. 21 were found in the chest, 16 in the left, and 5 in the right. She received a whole lot of injuries. She was hit a lot of times. She was stabbed numerous times by numerous weapons. Does that suggest to you, simply because more than one weapon was used, that there was more than one intruder or more than one killer? We suggest not. We will tell you later in our argument this morning why we believe that. Let's think about Kimberly MacDonald, the 5-year-old. She also got hit by this club. We submit the evidence shows. Dr. Hancock, who performed the autopsy on her, said that she had at least two hits to the head. It fractured her skull. The base of the skull. You saw that really just horrible picture of the back of her skull that was cracked in 6 to 8 places, he said. As I recall Dr. Hancock's testimony, he said that if she hadn't got hit again by anything else, she probably would have died or could have died from those blunt trauma injuries. Her nose was broken and pushed off to the right. She had a laceration on the left side of her head. It is interesting, as you recall the photograph. I don't know if it is here or not, but you have seen it just a little while ago right here, that when she was in the bed, she was laying on her left side where there is an injury. Now, she also received, according to Dr. Hancock, while she was at least clinically still alive. He could not count the number exactly because of the closeness of the injuries. At least 8 to 10 in size cuts to the neck that could have been made also by a single blade knife, such as the old hickory knife. What about Kristen? The 2-year-old or 2.5-year-old, we submit killed in her own room and perhaps in her own bed. She didn't get hit with the club. She was the only one that didn't. But she got hit a lot with the knife. We submit. And a lot with an ice pick. At least 33 times, somebody at least 33 times, raised a hand and came down in her body, with what we submit the evidence shows was either an ice pick or a sharp knife. Did the killer have to have those two weapons at the same time? Not necessarily. Not necessarily. You recall the testimony of Dr. Hancock that the ice pick or the puncture wounds were rather superficial compared to the stab wounds, one of which went through the heart. You remember that, Doctor? Hancock said that she had some cuts. I don't recall which finger, but on several of her hands, and one sort of long cut in the nature of a defensive wound. You know what that suggests, ladies and gentlemen? It suggests that before Kristen MacDonald died, she knew what was going to happen because she fought back. Now, what about the defendant's injuries? There has been a tremendous amount of testimony about the defendant's injuries. I think it is undisputed from both sides that at least he had a contusion on the left side of his face or head that was non-bleeding, and that according to, I think, Dr. Gemma, and perhaps one of their own doctors, could have caused unconsciousness. Although, as I recall the testimony of Bronstein, he could not predict whether or not immediate unconsciousness would result. Dr. Bronstein stated that unconsciousness could not have come from bleeding wounds. You recall Dr. Jacobson, who said that he had 4, what he called punctate injuries in this area, indicating, sort of in a line, 1, 2, 3, 4 close together. I think he used a fork or something like that when he testified as to what it might have been made with in his opinion. You recall the testimony, I think, of all the government's doctors that he did have a cut over here, indicating that did not require suturing or extensive medication. He had a cut right in this area of his body, indicating, which I think went this way up and down, indicating. It did not require suturing, although Dr. Gemma, in fairness to the defendant, said that perhaps he should have done that or could have done it, but it was not done, and that it would heal on its own. Of course, he had an injury to the right side, which caused the pneumothorax. Think for a moment of the testimony of the government's doctors, and even on cross-examination, the defendant's doctor, who stated that it was a treatable medical injury, and that in his opinion, any injury inflicted to the chest is potentially fatal. Recall the testimony of Dr. Gemma, who said, as I remember, that if you got proper medical treatment, the insertion of a chest tube and the chest tube worked properly, that there was very little, almost no risk of it developing into a tension pneumothorax. Well, I am not going to stand here today and argue for long, ladies and gentlemen, over whether a pneumothorax is or is not potentially life-threatening or not life-threatening. That could go on all day long, but I do submit to you, ladies and gentlemen, even if the government concedes, which we do not, that that was a potentially life-threatening wound, even if we concede, which we do not, that point. How many did he get compared and contrasted with the number his family got? 1. How many ice pick wounds did Dr. Bronstein say he saw in Jeffrey MacDonald's chest? None. How many ice pick wounds did Mike Newman, the first person who washed up the defendant, say he saw in MacDonald's chest? None. How many ice pick wounds did Frank Gemma say he saw? He said that he didn't observe any. Now, of course, on the defense case, two of his friends, half character, and they were doctors. They observed the defendant, and they saw some injuries that they said could have been made or were puncture wounds. Of course, when they drew on the diagram over there, as I recall, they drew a lot, and they didn't always match as to where they saw them. Ladies and gentlemen, they didn't read the medical records. They didn't examine, by their own testimony, the defendant. Now, I am not trying to suggest by and in of itself that because the defendant was not killed, he is therefore guilty of the slaughter of his family. I don't think that is sufficient evidence. I am not saying that. I am saying that when you compare and contrast his injuries to their injuries with the other physical evidence that we have, it certainly should raise in your mind the question as to why he was not hurt worse. The coloring, according to the government's doctors of the defendant, was good. His condition, according to their testimony, was good. He walked to the funeral. He was out of the hospital in 7 or 8 days. In 7 or 8 days, Kimberly, Colette, and Kristen went to Long Island to be buried. Now, we heard a lot of testimony during the defense's case about drug abuse. We even heard yesterday from Dr. Hughes. We heard Major Williams talk, gracious at length about all the people that had grudges, perhaps, against the defendant. He said, as I recall, when he heard that the defendant's family had been killed, "My God, the drug people have gotten him," or something to that effect. You recall that they were concerned that perhaps MacDonald was a fink because perhaps there was no privilege between a doctor and a drug patient at Fort Bragg. Okay, we see all of that. If that be true, ladies and gentlemen, let me ask you some questions. Why, if they had a grudge against the defendant, didn't they kill him? Why, if they came there for wanton destruction, didn't they kill everybody, particularly one who could identify them? Why do you kill a 2.5 and a 5-year-old, and don't kill the strongest person who can hurt you back? Why did the intruders leave the defendant alive? Now, you recall the pajama top. Why did he not get more serious injuries? Well, of course he was defending himself. You recall the testimony of Stombaugh, Thornton, and the defendant himself on the stand, particularly on cross-examination last Friday. We tried to simulate it, and of course we couldn't exactly, and I don't pretend that we did. But he said, as I recall his testimony, that it wasn't next to his body like it was on the ham. It was probably away from his body. He said, as I recall, he didn't move it like Brian and I did in the courtroom, so it tore. I think he said that he sort of held it like this, indicating, and that the person who had the ice pick came at him not like I did, but from like this, indicating. Ladies and gentlemen, according to the testimony of Paul Stombaugh, this thing has got at least 48 holes in it, puncture holes. Is the defense saying that in a life and death struggle, you stand there with this thing, indicating, in a relatively stationary position, while somebody comes at you like that, indicating, I don't know how many times, and doesn't hit your wrists and doesn't hit your arms? Where are the ice pick injuries to his hands? Where are the ice pick injuries to his wrists and arms? By everyone's testimony on this subject, there were none. I submit that that story is not worthy of your belief. I suggest that the evidence shows this thing, indicating, was never held like that. I suggest that the evidence shows that if it were, those holes, you can look at it, you can look at every single one of them. Those holes wouldn't be like that. They would be torn, and they would be ripped, and the defendant would have some cuts on his arms, or his wrists, or his hands to coincide with the punctures by the ice pick. Ladies and gentlemen, I suggest that the evidence shows that there was, in fact, a life and death struggle in the house that night. There truly was. I suggest that there were at least 2 white people involved in it, I suggest the evidence shows that there wasn't a black person involved. There was only one white male and one white female. The white female was Colette MacDonald, and the white male was her husband, Jeffrey MacDonald. I suggest to you that some of the injuries that Jeffrey MacDonald sustained could well have been inflicted by his wife, Colette. We know from the evidence, ladies and gentlemen, that she fought. She fought mighty hard before she died. You don't get both of your arms broken by standing there waiting to be killed. You don't get all the injuries she got just standing there waiting to be killed. You just don't do it. You recall the testimony of Gamble and Hancock, particularly Gamble with Colette. He said that the stabbing injuries came at a perpendicular plane, perhaps while the body was flat, suggesting again that she was struck first with the club. Compare, ladies and gentlemen. It is incredible that he got with what they got. If they wanted to kill him, why didn't they? What was their motive? We know from the autopsies that it wasn't sex abuse. We know from the testimony of Bill Ivory, who testified, I think, on a question on cross-examination for 5 or 10 minutes. It was not vandalism, in his opinion. The house did not look ransacked. The clothes in the closet were still hanging. The furniture was not taken. Of course, the defendant stated, as I recall, some rings were taken. We have only his word that those rings were there the night the murders occurred. He stated that the wedding ring of his wife, Colette, he had never seen and been introduced into evidence. What do you think that is, ladies and gentlemen? It was taken from her left ring finger, according to the evidence in this case. The defendant stated that 4 intruders came to his house that night. We heard a lot of testimony about intruders. We had hippie day and hippie week, I suppose, in this courtroom. First, we had, I think it was a Wednesday afternoon, Mr. Milne. You remember Mr. Milne from Virginia. He is the fellow that saw 3 people in 3 sheets, white sheets, as I recall his testimony, walking behind his house, which he saw just after he had been working with some glue or working on a model airplane or boat. He went to the back door and saw them. They were talking in a monotone voice, as I recall his testimony. They were all 3 carrying candles. It wasn't raining. The girl was pretty. She had long blonde hair. They come around the house, and he sees them going toward the MacDonald house. He said, although he doesn't see them go in the house and does not know whether they went right or left on Dougherty or onto Castle Drive. Because of his own personal concerns and work, he doesn't mention this to anybody. He doesn't tell his friends the next day after he learns of the murders. He tells his brother, a lawyer, a year or 2 later. He tells the defendant some years later, but he doesn't tell the FBI, doesn't tell Don Murray about a month or so ago. Not one time on his own initiative. Not one time did Mr. Milne ever seek to talk with a law enforcement agency about what he saw. The time, ladies and gentlemen, that he said he saw these people, even if you believe what he said is true, and I suggest that it is not worthy of belief, but even if you do believe it, what was the time that he saw these people? By his own testimony, it was 12 o'clock. What time did the defendant say that he went to bed as best he could recall? At 2 o'clock in the morning or at 2:15? What did these 3 people in the sheets do for the 2 hours between the time Milne saw them and the time they went into the MacDonald house? Or 2 or 3 hours? Did they walk around with the sheets in the rain, as it was raining later on according to the MP testimony, around Castle Drive, and just wait for the others to come? What did they do? Milne did not say that he saw a floppy hat. He didn't say that he saw any weapons, but the defense wants you to believe that those 3 people might well have been the people who went into the MacDonald house. Don't you believe that? What about the girl that Micah saw at the corner of Honeycutt and North Lucas? Micah, who we brought out on our direct case, the second witness, said that he saw a girl. What was she wearing? Well, she had a hat, a a rain hat. I think he said, had a raincoat or a coat. Did the defendant describe the girl he saw as wearing a coat? I don't believe I heard that. Micah also said that she had nice legs. Well, that may seem sort of silly, but, that is quite important, because if it is credible that Ken Micah saw a girl, you have got to believe that over here. It is just as equally credible over here that you have got to believe that he said she had nice legs. Why is that important? Because the defendant said that the girl he saw in his apartment, the last thing he saw as he fell unconscious was a part of a knee or leg and high-topped boots. The girl Micah saw, I suggest the evidence shows, was not the girl described by the defendant. Then, of course, last Friday and Monday, and maybe even part of this Tuesday morning, we had Hippie Day. We had Helena Stuckley Day. Perhaps one of the most pathetic, tragic persons who has testified in this courtroom, Helena Stuckley. She said, as I recall her testimony, that at 12 o'clock she was in the driveway with her friend, Greg Mitchell, who gave her a hit of mescaline. She did not have her blonde wig on at that time. It was perhaps in the closet in her house. At 12 o'clock, she was in the driveway, and she knew where she was, and she said that was a 20-minute drive away from Fort Bragg. Isn't that interesting, ladies and gentlemen? The defense, on Wednesday, puts on some testimony that Milne saw all these girls, the girl and two guys, at 12 o'clock, and at the same time on Friday morning, they put on another witness, who they contend, or I think they will argue, was this hippie girl, and she knows where she was at 12 o'clock. These are two mutually inconsistent stories. The only thing that links Helena Stuckley to this crime scene is the fact that the defendant says that he saw the girl, and poor Helena doesn't know where she was between 12 o'clock and 4:30 in the morning. She doesn't have an alibi. She said on cross-examination that the first time she heard of the murders was when she heard it on the radio when she got home. You heard her testify that she was harassed by the cops. You heard her say that she got rid of her hat, but you heard Mr. Beasley say that the hat he got from her was black. But Dr. MacDonald says that the hat he saw was white. Again, a mutually inconsistent fact. Now, ladies and gentlemen, just because Helena Stuckley doesn't know where she was does not make her the person on trial in this case, and doesn't make her the person that was in the MacDonald house that night. You heard her testimony when she looked at some pictures on redirect on late Friday afternoon. They showed her a picture of Kristen, the one I think that Brian showed you this morning. She said, as I recall, "That girl looks familiar to me." She didn't say that the scene looked familiar to her. She said that the girl looked familiar to her. I said, "Well, where do you think you could have seen her?" She said, as I recall her testimony, "Well, it might have been, around Fort Bragg or somewhere on post." They made a big deal about the hobby horse, that the hobby horse, looked familiar. Ladies and gentlemen, we showed you yesterday. The one thing we did on rebuttal evidence, the only thing we did. We showed you the fact that the newspaper on the day after the murders had a photograph of that hobby horse in that room in the paper. I suggest to you that you can infer from the evidence that's where Helena Stuckley, if she saw that hobby horse at all, saw it, like everybody else in Fayetteville, in the morning newspaper. She was on drugs for a long time, but that doesn't make her guilty of murder. I asked her on cross-examination if she did participate to her own knowledge in the killing of the MacDonald family. She said no. The only thing that she said was that she didn't know where she had been. You heard the testimony of H.O. Medlin, the fingerprint examiner, testify that he was given record prints of Helena Stuckley. They were not located in the MacDonald apartment. They were not found there. Then we start on some drawings. We noticed that 4 drawings were taken in 1970, and then 4 drawings were done 1979. A little bit more specific, with the girl looking a little bit more like Helena Stuckley, except for the chin, as I recall, and perhaps her hat. We know that a cross was found around one of the necks that wasn't in the picture in 1970, a little bit more specific. We narrow it down to Helena and her friends matching over the other two. Why was it necessary, ladies and gentlemen, if the photographs and the drawings were good enough in 70, why weren't they good enough in 79? I suggest that you infer from the evidence that the reason the new drawings were made were to look like Helena and her friends. You recall the question and answer of Dr. MacDonald on cross-examination about Helena Steckley when we read to him the testimony at the Article 32. Have you ever seen this photograph? I think it is G105, the picture identified by Helena on the stand as a picture of her. Have you ever seen the girl in that photograph before? It is a full front page picture of her face. Do you know what he said? He said, "No." Then they come in here and try to make you believe that Helena was the one, when the defendant himself in 1970 said that he had never seen her before. In any event, ladies and gentlemen, he said on his own direct testimony, and maybe cross too, that he only saw her for a second or two. She was the least person that he saw. They make a big deal about the three people around him carrying candles. The defendant himself is not even sure that they had candles. He only knows that there was a flickering light. Ladies and gentlemen, think for a moment what you need to make the defendant's story concerning the intruders and what happened to him make sense. First of all, you need 3 sheets which were left outside the house. You need some candles, at least 3. You need a white hat, according to his story, a dark hat, according to Mr. Beasley. You need some boots. You need a feather. You need a club, other than the one right here, indicating, perhaps like a baseball bat. You need a motive for them. Randomness. If it was randomness, why didn't they kill him? If it was motive because of drugs, why didn't they kill him? If it was vandalism, why didn't they take something? Why were syringes and medicine left in the MacDonald apartment? Ladies and gentlemen, the defendant's theory of defense in this case has sort of been like this. I tell a story, and you are to trust me. I am telling the truth. I loved my family. I loved Colette. I loved Kimberly and Kristen. Trust me. I couldn't have done this. I could not have done this. There has been a lot of character testimony. They say I can't do this, and therefore because I am not the type of person, I couldn't do that. Ladies and gentlemen, as Brian Murdoch told you this morning, if we convince you by the evidence that he did it, we don't have to show you that he is the sort of person that could have done it. The other part of their theory is to attack the Kassabs, attack the CID, attack the Justice Department, and even attack the government prosecutor. What they really want to do, ladies and gentlemen, they want to create confusion by all the hippie stories and by all the intruder information. Create confusion. They don't really care, I suggest, whether you believe Mr. Milne or Helena Steckley or the people to whom Helena Steckley spoke, or the girl that Micah saw. They don't care which one of those you buy, just so long as you buy one of them. I suggest to you, ladies and gentlemen, that if we prove to you that that was MacDonald's footprint in a tight blood, as I will later speak to, if we prove to you that Colette's blood got on that pajama top before and not after it was torn, then it doesn't make any difference if there were 5,000 hippies outside Castle Drive at 4 o'clock in the morning screaming, "Acid is groovy, kill the pigs," because they have not shown that those hippies were inside the house. It doesn't matter what was going on outside unless they can also tie that into the inside. That is where the people died. They didn't die outside on Castle Drive. They didn't die out by Milne's apartment. They didn't die at North Lucas and Honeycutt. They didn't die in Helena Steckley's apartment. They died at 544 Castle Drive. For all we know, ladies and gentlemen, the defendant himself did, in fact, see the people that Milne saw, and that is where the story of the intruders came from. We don't know, ladies and gentlemen. I can only tell you from the physical evidence in this case that things do not lie, but I suggest that people can and do lie. Ladies and gentlemen, the defendant, by all the evidence, is an outstanding doctor. I don't think anybody could dispute that. In 1970, he had a lot to live for. His wife, Colette, had a lot to live for, too. She had a dream, according to his testimony, of a farm in Connecticut with children 5, animals and cats and dogs and horses. The children had a dream, too. They wanted to grow up. They wanted to be alive. They didn't get that chance. The defendant wanted to continue, I suggest, his career as a doctor. I think it is reasonable to infer from the evidence. You heard Dr. Hughes yesterday talk about his airplane, his boat, his car, his medical kits, and the money it must take to buy those things. You can't have those things, ladies and gentlemen, if you are in jail. If we are correct, and the defendant did what we claim he did. If he could murder his family, think for a moment what he would do on the witness stand to save his life and his career. Think, ladies and gentlemen, about that when you judge the testimony and credibility of all the witnesses, and you put us to the same test that you put Paul Stombaugh, Ken Mika, or Richard Tavere, or any of the defendant witnesses. They have tried to create in this trial reasonable doubt, which is fair, because we have got the burden of proof of reasonable doubt. We have got to prove it to a moral certainty beyond a reasonable doubt, and we think we have done that, not an emotional doubt, but beyond a reasonable doubt. Now, of course, the burden of proof never shifts to the defendant. It is always the government's burden of proof. But the defendant chose to present evidence for something over 2 weeks. And what was the evidence that you heard? It was evidence of character testimony, of intruders, a story in which he really did not attack our physical evidence, and about 2.5 days of expert testimony concerning the physical evidence in this case. Ladies and gentlemen, I would suggest to you that when you compare what their experts say with what our experts said, and we will come to that in a little while, you will see that the physical evidence in this case, after all the dust has settled, is still up there standing and it hasn't been knocked down.
11 a.m. break.
Ladies and gentlemen, you might recall about 15 minutes ago, just before the break, we were talking about the defendant's story of the intruders. When you take all 7 weeks that you have all been here and all these charts and all this testimony and all the bench conferences and you pour them all out the window, you are left with 2 things, and it is those 2 things on which I suggest that you have got to make a decision. You don't make your decision on who has the best charts or which experts got the most degrees and who has published the most in the field. We will concede that. We have not published in the field very much. We have been out in the field. It boils down to 2 things. One is the defendant's story and his credibility that it is true. If you believe it is true, if you believe everything he said, then your task is relatively simple. You will acquit him. If, on the other hand, you contrast that with the physical evidence and somehow it doesn't wash, it doesn't make sense, then you have got a little bit more of a difficult task, and it might take you a little longer. I suggest that when you compare and contrast his story versus the government's story, testing the credibility of the government's case as well, as I think you should, you have got to come down on one side or the other, because I suggest to you that the evidence in this case, if it shows nothing else, it does show that what he said and what the physical evidence says are not reconcilable and that they are diametrically opposed. Brian Murdoch spoke briefly about the crime scene. If you believe that because Richard Tavere picked up the telephone on which no prints were later found, if you believe that a broken flower pot picked up by a medic, if you believe that some clothes in the hall put on the sofa by Joe Grebner, if you believe that Bob Shaw, in picking up the glasses and looking for a fleck of blood, interestingly enough, found to be consistent with the same blood type as that of Kristen, if you believe that these things, along with letting the garbage can be emptied before they looked into it, if you think that all of those things are so important and so bad that you have got no choice but to acquit the defendant, then I think you ought to do it. Smoke a cigarette and do it. I suggest to you, ladies and gentlemen, those things, really, The only things that are significant that the defendant has shown that were not done correctly are not relevant. Whether or not H.O. Medlin fingerprinted the whole part of the master headboard, and when he only printed the part where the word pig was written, doesn't change the outcome of this case. You remember the door that Dr. Osterberg said ought to have been printed on every side. He forgot to say whether or not it was open when the people came in, making it relevant or not relevant, as to whether it was, in fact, dusted for prints. If you believe that because the film moved when a truck or something went by, and some of the prints had to be retaken 2 months later, and as they were by maybe not as nice a camera as the defense had, but the only one that the government at that time had at the CID, if you believe that that entitles the defendant to an acquittal, then acquit him. I suggest that none of those mistakes change what is here. We aren't asking you to convict the defendant on what might have been. We are asking you to convict the defendant on what we have got. What is here, not what is not here. Not what we didn't find, but what we did find. What about his story? You recall last Thursday, he took the stand for the first time on direct testimony. He stated a lot of things and told briefly the story of the intruders and how he was struck. As I recall his testimony on direct, he was rather vague. His memory was rather vague about how it all went down. You remember Friday on cross-examination the questions that we put to the defendant. Let's take his story and let's go through it, the crime scene, and see how it fits with the physical evidence. First of all, he said that some intruders met him in the living room, right there, indicating, and he drew these people. There was 1, 2, 3, 4. The girl was number 4, I think, and she is the one that might or might not have had the candle. He wasn't sure. The black had the club, but I think he said on cross that it was probably not this club. I think it was round like a bat and didn't think it was this club. As I recall his testimony, he said that the first time he ever saw this club was the 6th of April, 1970. Isn't that interesting when you compare the testimony of the government experts that this was, in fact, the murder weapon used on Colette and Kimberly, certainly, or a murder weapon, and that it did come from the house, once part of the piece of wood that formed a bed slat in Kimberly's room, but he didn't see it until the 6th of April, 1970. How many threads, purple, blue, yellow, green, any color, were found in the living room? You heard Bill Ivory and Mr. Medlin say that they went through the nap of the carpet in the living room. How many threads, yarns, and fibers did they find? Not a single one. How much blood, where he says he was struck with a sharp blade, was found in the living room, on the sofa, on the wall, on the floor, on the table, on the glasses, on the Esquire magazine, on anything that matched his blood type? None. How many splinters were found in the living room that matched anything? None. But we know that splinters were found in Kristen's room, Kimberly's room, and the master bedroom. Now, on cross-examination, I recall that I asked the defendant about the bee blood. If the jury should find, as I have just told you, did he have an explanation for that? He said, well, it is obvious that the wound did not bleed too much. Well, perhaps that makes sense until you remember, ladies and gentlemen, that by his testimony he believed, although there is a question mark, but he believes that he did not go to the hall bathroom until number 6. He did 6 things. He first went, as I recall it, after he was knocked down here, indicating, and fell here, indicating. He goes to the master bedroom, and then to the kids' rooms, and then to the hallway, and then somewhere else, before he goes back to the hall bathroom and washes off his hands for the first time, washes off his hands. His hands were bloody according to his own testimony. He had touched 3 dead people who had bled a lot. You recall his testimony on both direct and cross. I saw a lot of blood. Well then, why is the blood in the bathroom sink, according to the government testimony, that of type B, which matches his, rather than type A, type AB, or O, which matches his family. Well, perhaps this blood came from him, on his body. That is all right, until you think for a moment that if the wounds didn't bleed too much over here, how come he bled a lot more over here? You know, he said that he lay unconscious. For how long he did not know. Right there. How much blood of type B was found on his pajama top, which he said was under his wrists? Very little. How much type B blood, if any, was found here? Ladies and gentlemen, I suggest to you that the reason and the explanation why there is no type B blood in the living room, why there are no splinters in the living room, why there are no threads and yarns is really a very easy answer there, I suggest to you. You can infer from the evidence. What you can infer from the evidence is 1. The pajama top wasn't torn then. 2. A club did not splinter there. 3. Nobody bled there. And 4. You can infer from the evidence that no struggle took place there. Now, I am not about to suggest in what I am getting ready to say in the next few minutes that the burden of proof ever shifts to the defendant, because it doesn't. It stays with us. You recall on Friday that we asked a lot of questions, that if the jury should find this and that, did he have an explanation of that? You recall essentially his testimony. It would be pure conjecture, or no, or I can't recall. Perhaps he does not have to explain, but think for a moment if you were on trial for your life, and the only thing that made your story perhaps not believable was the inconsistency of the physical evidence. Don't you think if you could explain it, you would? Don't you think for one moment if you were on that stand and somebody asked you a question, like I asked Dr. MacDonald, and you could tell me, Mr. Blackburn, you are an idiot. Here is the answer. Bam. Doesn't it make sense that you would do that? I suggest that it does. Let's go to the master bedroom. You heard this morning from Brian Murtaugh and earlier in the trial from a number of government witnesses, Paul Stombaugh, Dillard Browning, and others, a number of threads and yarns microscopically matching the pajama top were found there. As I recall the testimony, I think there were over 60 purple cotton sewing threads, which matched identically in composition, color, and texture to the blue pajama top. Over 18 blue polyester yarns matching the pajama top, and at least one blue-black sewing thread matching that top. What does that suggest to you? I suggest that you can infer from the evidence that they got there because that is where the top was torn. Now, what does the defendant say about that? He says, as I recall his testimony now and in the past, that he doesn't know where the top was torn. It could have been torn here, or it could have been torn in the master bedroom. We asked, did you hear any ripping sounds when you were in the master bedroom? And he said, no. I asked him if he had an explanation for why there were no threads in the living room. He said, well, it would suggest to me that perhaps it was not torn there. It was pulled over my head. You also recall his testimony that he said that he didn't remember backing his head through the pajama top. It is either one or the other. Now, if the pajama top was pulled over his head, what were all these 4 people doing while it was being pulled over his head? Was the guy with the club standing there like that, waiting until he got it around his wrists before he could bash him again, because it is not fair to hit a guy when he is down? What was the guy with the ice pick or knife doing? Again, waiting. Didn't want to hit him in the back. He was going to hit from the front. You know, it is a coward that hits in the back. They weren't very courageous when they hit Kristen from the back, were they? Ladies and gentlemen, I suggest to you that even if the pajama top had been torn in the living room and miraculously had left no threads or yarns, you recall the testimony of Paul Stombaugh of how it is torn. It is torn down the front. If it is torn down the front, does that tie up your hands? No. It would leave them as they were, I suggest. You have heard the testimony of Paul Stombaugh, who stated that with respect to the pajama top, it was torn, in his opinion, down the front. It was a V-neck. It was torn in the front, you know, while the person was stationary tearing it like that, or as the person turned away. Isn't it interesting, ladies and gentlemen, that the defendant has 4 little marks right here in a line? I suggest that you can infer from the evidence that Colette MacDonald pulled that pajama top, or that she did like this, indicating, with her 4 fingers, and ripped it down the front, and it was torn in the master bedroom. That is where those cuts or scratches or punctate marks or what have you come from. What about the blood? The type A blood that Paul Stombaugh testified was on the pajama top before it was torn. You remember you heard a lot of defendant experts say, well, Stombaugh is crazy. That is not a left shoulder. That is not this, and that is not that. Did you hear defendants experts say that there wasn't type A blood on the pajama top before it was torn? Did you hear that? Don't you know if they could have had an expert here from somewhere, they would have had to have said that? Because, ladies and gentlemen, the defendant's story is that he placed the pajama top on Colette after she was dead. There is not one whit of evidence to suggest that after it was placed on Colette's body, it was then taken up and ripped. All of the evidence suggests that however it was ripped before and not after it was placed on top of the chest of Colette MacDonald. Well, what does that suggest to you? It suggests, ladies and gentlemen, that Colette MacDonald bled on that pajama top before it was torn in 3 places. If that be true, if you should find that from the evidence, I suggest she bled while she was alive and engaged in a struggle with whoever was wearing that blue pajama top before, not after, it was torn. We asked the defendant if he had an explanation for that, and he said not to his knowledge. Don't you know that if he could have explained it, he would have explained it? We even know that Kimberly's AB blood type was on the pajama top. How did it get on there? Well, we know, if you believe the defendant's story, that on the first visit to the master bedroom, the first circuit, he took it off and put it on her body, and then he went to check Kimberly, and then he perhaps got Kimberly's blood on it. He did not see Kimberly until he had the pajama top off. How does the AB blood walk from Kimberly's room over here to the master bedroom and get on the pajama top? We asked him that question, and his response was, it would be pure conjecture. He also testified that in 1970, he did not know the blood types of his family. Oh, that he did. You know, we say there is no such thing as a perfect investigation. There is no such thing as the perfect crime. We know that the pajama top, at least, was placed on Colette's chest. That is one thing with which the government and the defendant is in agreement. Why? He said that he was in a state of confusion, and that perhaps he put it on there to get her warm and protect her from shock, but he wasn't sure why. He was confused. Now, I would again suggest that that is something else that we would agree with the defendant. He was, in fact, in a state of confusion when he placed the pajama top on there. I think that you can infer from this evidence that the reason the pajama top was placed on the top of Colette's chest was because it already had type A blood on it, and he had to have an explanation that would sound reasonable as to why that type A blood was on it. We know that the pocket was on the floor. I asked him about that, and he said that he could think of a number of ways that it could be kicked over there and torn off when the pajama top was torn. Well, okay, but it is upside down, and it has got A-type blood coming from the outside in, and it is not spatters. It is contact. How did that happen? You recall Terry Labor's saying that, in his opinion, that A-type blood got on there prior to the pocket being torn off, and yet it didn't bleed from the inside out, but it bled from the outside in. We know that Mr. Smith in the opening argument talked at great length and very eloquently about how the government couldn't tell you, maybe, it couldn't tell you possibly, it couldn't tell you could have. That wasn't good enough. We had the burden of proof beyond a reasonable doubt. We had to tell you that it did. Ladies and gentlemen, we have proved. If we have proved anything to you, I submit that this club was the murder weapon a murder weapon, used to strike Colette and Kimberly. We know it had their blood type on it, type A and AB. We know that splinters from it matched identically in 3 bedrooms. We know that one splinter in excess of 3 inches long fits identically into this piece of wood and had A-type blood on it. I don't know what more we can show you about that club. That is not maybe. That is not possibly. That is not can. We know that there was blood on the ceiling. There was an indentation in the ceiling as somebody pulled that club over to hit Colette. We know that splinters matching that club are found in Kimberly's room, and that type A blood was found about 7 feet high in Kimberly's room, and type AB a little lower. We know that the club, from the evidence I think you can infer, was used to strike Kimberly a second time in that room. How did the threads and the yarns from the pajama top matching the blue pajama top get on Kimberly's bed on top, underneath the sheet? 14 of them, I think Paul Stombaugh testified. 14 blue purple cotton sewing threads and at least 5 blue polyester yarns. The pajama top was already off. Now, we asked the defendant about that, and as I recall his testimony, he said, well, it was sticking to his arms. We asked him if he got on the bed, and he said, no. We asked him if his arms were moist, and he said that he didn't know. Was there blood on him? Surely. If you believe that that is where they came from, fine. We suggest that they came from the blue pajama top itself, as Kimberly MacDonald was carried back into that room with that torn pajama top and placed in that bed. What about Kristen? We know that at least one thread and the splinter matching the pajama top and the club were found in that room. We know that type A blood from the evidence was on the wall in a splattered direction. We know from the evidence that type A blood was in massive direct bleeding amounts on the top sheet, but interesting, not the bottom. We know, ladies and gentlemen, that Colette MacDonald had no injuries on her legs, but yet there was a lot of blood, her own blood, on the pajama bottoms. How did that blood get there? I suggest from the evidence that you can infer that it got there because the killer took this club, and after Colette MacDonald went to Kristen's room, she was banged again with the club up against the wall and fell over and bled on the pajama bottoms. She didn't bleed any on the bottom sheet because something was preventing that blood from going on that bottom sheet. Perhaps little Kristen. Ladies and gentlemen, we have heard a lot about fabric impressions and contact prints. We heard Paul Stombaugh say that one print had an impression of a shoulder. You heard the defendant's expert say, that is not so. You heard the defendant say, well, he wasn't worried about that because that evidence had been disproved. The same thing with the handprints. We disagree. We say that it has not been disproved. How did they get there? You even heard Dr. Thornton. Don't you know that if he could have disagreed, he would have disagreed to say that one fabric impression contact print matched the right cuff of the defendant's blue pajama top? What did the defendant say about the bedsheet and the bedspread? To his memory, he could not recall touching or coming in contact with that sheet. You recall Dr. Thornton saying, well, the imprint could have been made by something that weighed as much as 2 pounds, I think he said. Do you think that weighs 2 pounds by itself? Ladies and gentlemen, if you throw away the left shoulder, just throw it away. If you throw away the prints, just throw them away. Which we are not going to do, but suppose you do that just for the sake of argument, you have still got a massive amount of type A blood in the center of the sheet. You have got 2 impressions matching Colette's pink pajama top, the arms. You have got MacDonald's blue cuff, the right cuff. How do you explain that? What is the explanation for that? You have also got type O blood on the floor and footprints. Poor Mr. Medlin. Even the defendant agrees. The left footprint was probably his. The intruders did not go barefooted. The left footprint was exiting and not entering that room was made in type A blood. Now, Brian Murdoch touched on that this morning. How was the footprint made? How did the fabric impression, the contact print, get there? I submit that it is reasonable to infer from the evidence that after Colette MacDonald was banged on the bed, she came to rest on the floor, because we know that in her hand, according to Dillard Browning, a yarn matching the throw rug in Kristen's room was found in her hand. We know that a hair ribbon was found. We suggest that that bedspread and that blue sheet taken from the master bedroom were brought into Kristen's room. She was laid on it, and ladies and gentlemen, she was picked up and carried back to the master bedroom and put down with her hair hitting the floor first because we know her left hand was over her hair. We suggest that as the defendant did that, you can infer from the evidence that he stepped, unbeknownst to him, in a blood type that was not Kristen's, and made those footprints as he exited that room. And that is how the fabric impressions and the contact prints were made. You recall the testimony of Paul Stombaugh and others for the government that a hair microscopically matching that of Colette MacDonald was found in the bedspread, intertwined around a thread from this pajama top, or microscopically similar to this pajama top, with blood-like deposits on its shaft. I suggest that that got there at that time. We know that pieces of latex were found and torn, and some with type A blood in the master bedroom. How did they get there? We asked the defendant about it, and he said, "Not that I can recall. No, or no explanation." Again, while he has no legal responsibility to explain, don't you know that if he could have, he most certainly would have? We know that Medlin stated that somebody wrote the word pig in type A, blood on the headboard, over where Colette MacDonald slept. We know that a blue thread or purple thread was found in that area matching the pajama top. We know that there is a good possibility from the evidence that those surgical gloves matched those in the house, but even if they didn't, even if you should find that they didn't, where did they come from and what were they doing there? Isn't it interesting, ladies and gentlemen, that droplets of type B blood, that of the defendant, is found in the kitchen near the cabinet where surgical gloves were kept? Looking at this chart, you can see that he didn't go there until number 13, drops of blood at number 13, but at number 1 where he was cut, according to his story, there wasn't any. He stated that he used both telephones, and I think there is evidence that at least one phone was, in fact, used, perhaps both. Both receivers were off the hook. He had no explanation for why there was no blood on those phones, and no explanation for why, if you find from the evidence that there was B-type blood in the sink. We suggest to you that you can infer from the evidence. The defendant, we do not contend, inflicted all of his injuries, not by any stretch. You know the contusion on his head. Remember the hairbrush in the master bedroom. I think you can infer from the evidence, ladies and gentlemen, that this defendant, with his medical knowledge, with his medical ability, knowing that MPs would soon be on the way, very likely inflicted one, not all, but one, injury in the bathroom. And that is where the B-type blood came from, and that was close to the end, and that is why B-type blood was not found in the kitchen until number 13. Perhaps the most telling thing of all, ladies and gentlemen, you come back to 2 pieces. You could throw the whole shooting match away except for 2 pieces of evidence. Brian will disagree with me, but I think you could just hold on to 2. These 2, holding up the club and pajama top. Why are they so important? Well, you remember, he said that he hadn't seen this until April 6th, and he didn't think this was the club that he was hit with. The club, the knives, and the ice pick were outside the door. He didn't go outside the door, but he went to it. They had A and AB blood on it, and some threads which matched, or some yarns which matched the throw rug in the master bedroom. They had 2 little purple threads on them, matching identically in composition with these, indicating. This sounds sort of minor, really, until you think about something. How did they get there? If he never touched them, if he never saw them, if the pajama top was not taken off of his body in the hall or the living room until this club was out the door? How in the name of all that is reasonable did they walk out the door and get on the club and stick to it? I suggest from the evidence that there is an explanation, and that is that this club was not outside the back door until after, not before, that pajama top dropped threads and yarns and blood to the floor, and as it fell on the floor it picked up the threads and picked up the yarns with the blood, and it was thrown out the door. I suggest that you can infer from the evidence as to how it got there. Of course, the defendant made a lot about his pajama bottoms, which he said were torn. Well, of course, we don't know what the known was for the pajama bottoms. If they were torn, how did they get torn? There is no indication that the intruders hit him below the waist, that they were torn below the waist by the intruders. And if they were, why didn't they drop some threads in the living room? Why didn't they drop some threads in the kitchen? Why didn't they drop some threads in the hall? Why didn't they drop some threads in the bathroom or the utility room? Isn't it interesting that they don't drop threads where the pajama top dropped threads? Ladies and gentlemen, I have talked to you a long time about all this type of evidence in the story. What does it all mean? How could this have happened? We know from the evidence that the defendant, as we have said before, was a good doctor. We know that his family loved him. We know that from the Valentine cards. We know that from the card that he read from the witness stand shortly before the end of direct examination, that Colette loved him very much. I suggest to you, of course, that what the defense tried to do was to prove the defendant's love and character through Colette, and not from himself. We know that the defendant had been unfaithful in his marriage. We know from the evidence that he had worked the weekend before. He was perhaps tired. We know from the evidence that there was maybe it is a minor problem, the problem of Kristen coming to the bed. We know that he, according to his story, went to bed late that night and found that the bed was wet. I am not by any stretch of the imagination suggesting that the slaughter took place over any one thing. I don't think so. But I think that you can infer from the evidence that a fight developed in the master bedroom between Colette and the defendant. A struggle, an altercation. We know that Colette was bruised. Perhaps she was struck. You know those words. You heard them in Wade Smith's opening argument. Daddy, 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 daddy. I believe those words were said, but not from fear of intruders. But I think that you can infer from the evidence that they were said as Kimberly came to the master bedroom to find out what was going on from her father and mother. We know that she was there. We know from the evidence that her blood was found on the sheet, on the floor, and in the hall, or at least her blood type. I suggest that you can find from the evidence that it was her blood. We suggest, perhaps, that Colette MacDonald, in an attempt to save herself or to fight back, got the old, dull Geneva forge knife that perhaps struck the defendant that was sitting around for what purpose we don't know. We know from Dr. Gamble that Colette MacDonald had a bruise in this area of the chest, indicating. I suggest that the defendant, perhaps in a frenzy, perhaps mad, perhaps disgusted, perhaps exhausted, perhaps tired, he knew that he was going to be away for 30 days in March, if he could, while his wife was 6 or 7 months pregnant. Maybe to fend off his wife, he hit like that. But I think you can infer from the evidence, ladies and gentlemen, that the defendant in one tragic brief moment, so brief, lost control and came back with that club. And as he did, he struck Kimberly and struck his wife, perhaps not originally trying to hit Kimberly. Perhaps she walked into the club. At that point, ladies and gentlemen, the future is at stake. It may be too late at that point to undo that which is done. You know how hard it is to unring the bell. You know the words, Jeff, Jeff, Jeff. Why are they doing this to me? Think how close that is to Jeff, Jeff, Jeff. Why are you doing this to me? You remember Pamela Kalin, who said that she didn't hear anything that night? You remember Pamela Kalin and Mildred Cassab, who said that they did not smile as much as they used to, but she still gave Colette some money because all money problems weren't over. After Kimberly was struck, we suggest that you can find from the evidence that Kimberly was picked up and carried back to her room and struck with this club again, and that Colette, because we know that Dr. Gamble said that she would not have died from these club injuries, went to protect or see what was happening to Kristen, and while she was in there, Kristen had the misfortune to see or know what was going on, and Colette was struck again and carried back to the master bedroom. Then, of course, again. Ladies and gentlemen, you must understand that I think you can find from the evidence. Again, things had simply gone beyond repair. You can't go back and make the family happy again, drink liqueur, and watch Johnny Carson. It has gone too far. An old hickory paring knife, we suggest, was located. While there is no direct evidence that that knife came from that house, there is evidence that that was a common knife around Fort Bragg, and that the MacDonalds had paring knives, and that that knife was taken, and Colette MacDonald was stabbed 16 times, and Kimberly was stabbed in the neck at least 8 to 10 times. I think that you can infer from the evidence that, you remember the Esquire magazine and the words in it, the Manson-type murders, and the multiplicity of weapons equaling the multiplicity of people. An ice pick was obtained, from Mildred Cassab and Pamela Kalin, that they had seen an ice pick at the MacDonald residence, and even though the defendant said he did not recognize it, we suggest that it was there and that you could find that from the evidence. That was taken, and Kristen was stabbed superficially with the ice pick after she had already been stabbed with the knife. You remember the testimony of Paul Connolly, who said that the defendant became inconsistent and confused when he talked about Kristen. Kristen was so hard to talk about. Perhaps that was because it was the most cold to do. A defenseless little girl. Kimberly and Colette had perhaps been struck while angered, but not Kristen. Well, I said there wasn't a perfect murder. The pajama top was probably already on Colette's chest. I think you can find from the evidence that the defendant forgot it was there and made that terrible mistake of stabbing Colette with the ice pick through that blue pajama top, and that is how those holes got there. He didn't know at that time that 4 years later, Shirley Green with the FBI would figure out that 48 can match 21. You remember the defendant said that Thornton said that was worthless because she didn't know whether they were entry or exit holes. Yet, on cross-examination, you recall that he said that he read from the FBI report of Paul Stombaugh, who said that when he got the pajama top, it was a year and a half later, and he couldn't be sure whether any of the holes were exit and entry holes. I suggest to you that there is only 2 explanations for how the pajama top got the holes in it, either his story or our story. I suggest that they got there one or the other, and I suggest that the evidence shows to you that they got there our way. I believe the weapons, the old hickory and the ice pick, you could find from the evidence were wiped off on the bath mat. Do irrational and irresponsible drug-crazed people wipe off weapons and throw them outside to be found by investigators? Why did he say that the Geneva Forge knife was pulled out of the chest of Colette, even though Paul Stombaugh testified that in his opinion that knife was dull and did not make any of the cuts in the clothing? Remember, he said, don't forget that I pulled the knife out of her chest. I suggest that you could find from the evidence that he did that because he didn't know what was on that knife, and he had to have an explanation for it as to why it was where it was. He forgot to throw that one out. I suggest that the Geneva Forge knife didn't kill anybody. If he pulled it out of her chest, why does the evidence for the government suggest that there was no significant amounts of blood on that knife? Perhaps because it didn't go in that chest. It nicked the defendant's arm. I believe that the surgical gloves were then taken. I think you can find from the evidence, and used to write the word pig on the headboard. The self-infliction of one injury was made, the story was concocted, the MPs were called, and he laid down next to his wife to wait for help. That help came, and this confusion began as they tried to get him to the hospital. Who created so much of that confusion? Who created the red herring of going to look for the intruders? We suggest that you can find from the evidence that the defendant did. Ladies and gentlemen, we have not presented an emotional case. We have presented a reasonable and sometimes boring, tedious, and logical case. We have given you the explanation that we believe to be true for how all this got where it did and what it means. You know, the defendant had a lot of nice character testimony, and I am sure that each of you, if you were accused of a crime, would have the same. Don't ever forget that perhaps the greatest crime of all was committed 2,000 years ago, and the night before Christ was betrayed, Judas Iscariot would have had 12 of the best character witnesses this world has ever known to have said he couldn't have done it, but you know that he did. Ladies and gentlemen, if in the future, after this case is over, if in your jury deliberations you should think again of this case, I ask you to think and remember Colette, Kimberly, and Kristen. They would have liked to have been here. They have been dead for almost 10 years. That is right now around 3,400 or 3,500 days and nights that you have had, and I have had, and the defendant has had that they haven't. They would have liked to have had that. If in the future you should cry a tear, cry one for them. If in the future you should say a prayer, say one for them. If in the future you should light a candle, light one for them. We ask for nothing in the name of persecution. We ask for nothing in the name of harassment. We ask for nothing in the name of what is wrong. Nothing. But God, we ask for everything in the name of what is right and in the name of what is just. That is why we are here. We ask for everything in the name of truth. We ask you, ladies and gentlemen, that this horribly tragic and horribly sad as it is, because you know that you have seen Mrs. Kassab and you have seen Mrs. MacDonald, and it is sad for both of them. Both of them were grandmothers, not just one. It is sad for the defendant. But it is sad most of all for those who paid the highest price of all, with their lives. And we ask you, ladies and gentlemen, to return a verdict of guilty as to clubbing and stabbing Colette, guilty of clubbing and stabbing Kimberly, and guilty perhaps most of all for stabbing little Kristen. You remember, I am sure you have heard it many times, part of the 13th chapter of Ecclesiastes. There is a time for everything under the heavens, a time to be born and a time to die. Surely God did not intend on the 17th of February 1970 for Colette, Kimberly, and Kristen MacDonald to die. It is time, ladies and gentlemen. It is so late in the day. It is time that someone speak for justice and truth and return a verdict of guilty against this man. I ask this jury to make what I know to be a very courageous decision that he did it, and we are sorry, but he did it. Thank you.
Siegel and Smith make their closing argument. The following is the rebuttal from Jim Blackburn.
You know, I couldn't help but think during the last 10 minutes listening to Wade talk about motive, you know, and the unbelievability of it all. And I suppose, in a way, it is unbelievable that a successful person might kill his family and that a person to whom his children cried daddy might raise his hand in anger or rage or coolness perhaps and kill his family. But I can't help thinking back to what I said late this morning. We don't contend. We don't contend that Dr. MacDonald killed his family because Kristen wet the bed. We contend, ladies and gentlemen, that the defendant killed his family because events overtook themselves too fast. Think yourself for a moment in your own daily lives if you have been angry at someone but not really meaning to be, and you have raised your hand, maybe to your own child. But you would never, you know, follow through. You stopped short. You didn't do anything. Suppose when you are tired late in the morning or early in the morning and you are worn out and things just aren't going right, that you do raise your hand, and before you can regret it, you have done something that is irretrievable. Everything else, ladies and gentlemen, we say in that crime scene, flowed from that moment. I don't say to you that the defendant, as I said this morning, has always been a bad person. I don't say to you that for the last 9 years he has been a bad person. But I do say to you that on the early morning of the 17th of February, time stopped in the MacDonald home, and for a flicker of a second, something happened, I think the evidence shows, which caused tragic events to unfold, and the killing of the children was necessary for self-survival. Mr. Siegel, in his presentation this afternoon, attacked again. He attacked us, he attacked the CID, he attacked Stombaugh, Shirley Green, and anybody who has ever been with the government, as I recall, was attacked. He said that our case was like a house built on sand. I suggest to you, ladies and gentlemen, the only sand in this case is that which was perhaps attempted to be thrown into your eyes to keep you from seeing the evidence in this case. He said that you would write the final chapter, and Wade Smith said that you might have the power to give the defendant peace. We suggest, ladies and gentlemen, that regardless of your verdict, whether it is innocent, or guilty, you don't have the power to give the defendant peace. He said that we're nonpartisan. I suppose there is a grain of truth in that. We are advocates. We are pushing a point of view, but let me tell you why. Because we believe it to be true. I am sure that Mr. Siegel would not suggest that we would push it for any other reason. He went over the burden of proof beyond a reasonable doubt, and I think implied to you that we had to show each little item beyond a reasonable doubt. That is not what we have to show. We have got to show you beyond a reasonable doubt that the defendant committed these crimes, however we do it. Whether we do it this way or that way, or whether you believe this or believe that. You could throw out 90% of our evidence, but if you believe the other 10% convinced you that the defendant was guilty beyond a reasonable doubt, that is okay, just so long as we convince you beyond a reasonable doubt that he did it. He talked that we had misstated some principle of law dealing with the burden shifting from the government to the defendant. We did not misstate that. We did say that he didn't explain it. You know, Wade talked a minute ago about what is inside. Well, that is all right. What is inside when the defendant takes the stand and does not attempt to explain the unexplainable, when he is asked questions and doesn't give an answer and relies on his counsel to answer for him. We rely, ladies and gentlemen, and ask you to rely on the law of common sense. I will repeat it again this afternoon because it makes a whole lot of sense to me. Don't you know if he could have, he would have. He says that the physical evidence doesn't say anything. It doesn't speak. It is only attorneys speaking. I say to you that the physical evidence simply cries out an explanation. I heard this afternoon little straw men being set up that we did not raise and then being knocked over by the defendant. He talked at great length about threads and fibers and his explanation for where they were. Isn't it interesting, ladies and gentlemen, that all these MPs and these people who were at the crime scene and tracked in and tracked out in the rain and all this other stuff, why didn't they track some back into the living room from the master bedroom? There were a lot of MPs, according to the defendant and the government, in the master bedroom. Why weren't some of those threads somewhere else? Miraculously, he asks you to believe that only the threads in the living room area were the ones that were tracked, and not those somewhere else. He talks about the movement of the bodies, and he spoke of Dr. Neal. He forgot to tell you that, Doctor. Neal testified from the witness stand that all the photographs of the bodies, or at least some of the photographs of the bodies, were taken prior, not after, but prior to his checking the bodies. The picture of the pajama top on Colette MacDonald was first taken by James Alexander before Dr. Neal ever got there. A little black and white Polaroid shot of it. One of the first photographs, I think, introduced in the trial. You recall that, Doctor? Neil says that he moved Colette. How did he move her? He goes over here and moves her towards him. He picks up the pajama top. Did he say that he went over to the bed and shook it out on the bed? Did he say that he went out and shook it out on the club? You didn't hear Mr. Siegel explain the club, did you? Not with respect to those two threads. No mention was made of that. Not one. Dr. Neal's testimony was contradicted by 3 government witnesses, Ivory, Shaw, and Connolly, who said that he moved the body of Kristen, but not the body of Colette and Kimberly. But whether you can reconcile that disagreement in your minds or not, it still does not change the fact that, even if you believe Dr. Neal and choose to disbelieve our 3 witnesses, so what? So what? If the photographs are taken before, if the pajama top doesn't go under the body, big deal. It doesn't change those threads and fibers, of which there were more than 60 in that room. He talks about the blood on the feet of Colette MacDonald, and that it wasn't checked. There is not the slightest indication that the footprint exiting Kristen's room belonged to anybody other than Jeffrey MacDonald. The defendant himself, on cross-examination, said that it was probably his. H.O. Medlin identified it. When you get to the point of why we only have his word and why the picture didn't take it, and Osterberg said, "Well, if you can see it, you can take a picture of it." Remember that Medlin said that he saw the ridge lines with a magnifying glass, and the photography equipment didn't have that magnifying equipment. That is why the ridge lines weren't picked up, according to the very testimony of Medlin, not because you couldn't see it. He talked at length about the crime scene and said we made fun of it. We don't intend to make fun of anything, and certainly not a serious crime scene like this, but I do fail to see the strong significance of the movement of things that have little or no evidentiary value. He even spoke about the glasses again today, and said that there was blood on them. Yes, there was blood, and the testimony was that it was consistent with that of Kristen, and inconsistent with that of the defendant. He said that we were talking about the hospital at Hamlet, and perhaps that is where it got on there. I don't recall that testimony ever coming, or that argument ever coming from the government. Maybe you do. He gave you a long list of people that were at the crime scene. Remember, of course, that all those people were not all there at the very same time. You recall the testimony of the MPs who stated that they stayed there a relatively short time. Even though Ivory didn't make a list of the MPs who were there, you remember that Bob Shaw said that he had someone do that. Ivory did not have to do every little single thing. He talked about the inconsistencies of statements between government witnesses and the defendant himself, and said that we were holding people by different standards. You have got to remember one thing. First of all, the government witnesses are not defendants in a criminal case. Secondly, you have got to remember 2 or 3 things. Secondly, the defendant. Government witnesses aren't attempting to live and get their freedom by their statements, but most importantly, he is showing inconsistencies between one witness and another witness, not an inconsistency between a witness statement and his subsequent statement at some later time. I submit to you that there is a tremendous difference when you say A and B disagree and A and A disagree with A. It is quite different, I would submit. He talks about the pajama top and where it was torn. I think by an implication, he said that MacDonald said that it was ripped in the master bedroom. MacDonald said that he took it off in the master bedroom and he did not hear a ripping sound. MacDonald said that he doesn't know where it was torn and he cannot come by his counsel and tell you, now we do know where it was torn. In any event, we don't disagree necessarily on that. We believe it was torn in the master bedroom. He talks about the fact that there were few yarns and there would have been few yarns because it wasn't torn in a seam area. Ladies and gentlemen, Paul Stombaugh did, in fact, testify that that blue pajama top was, in fact, torn in a seam area as well as other places. He talks about the sheet and the bedspread and the fact that you cannot draw any conclusions from that because it was wet, it was tacky, it was put together in a bag. Well, I recall his own defendant expert, John Thornton, whom Wade Smith has just said was outstanding. He said that there was a right cuff of the blue pajama top on that sheet. The defendant cannot have it both ways, ladies and gentlemen. You can either identify impressions on that sheet or you can't. You remember the testimony of Paul Stombaugh, who said, with respect to how long it takes blood to dry and the shoulder area in which he said there was a small amount of blood and that it would have taken 5 to 6 minutes to dry. To say now that when it was moved, that all the blood was wet, and that is where all the impressions came from, I think certainly begs the question on that. We submit to you that that testimony concerning that sheet and the impression on it is still extremely valid. He talked about the pajama top on Colette, and some said that her breast was exposed, but the photograph didn't show an exposed breast. He forgot to mention that whether or not you can see something like that and show up in a picture depends in great degree on the camera angle that you are taking the picture from. Ladies and gentlemen, I also think I heard him say that we contended that the pajama top was torn in Kristen's room and there weren't many threads there. No, we haven't said that the pajama top was torn in Kristen's room. I think there is a very valid explanation of why there were very few threads there. I think most of them simply had fallen off by the time it was taken there. I think that is why there were very few threads there. Ladies and gentlemen, the defendant has testified, and I would agree with the defense that on and the shoulder area in which he, numerous occasions, he piled a stack high, and that he always testified voluntarily, which I think is true. But you have got to remember something, ladies and gentlemen, and the defense keeps making a big spat of the fact that this is 1979, and that it is the same as 1970, and that nothing has changed, forgetting to tell you that in 1971 and 1974, not every single bit, but a tremendous amount of this evidence was reanalyzed by the FBI, and that the new investigation that resulted in this reanalysis and much of this evidence was done at the specific request of the defendant himself. Again, I think that the defendant is seeking to have it both ways. The defendant has told his story many times. The physical evidence has become additionally known at different times. For example, we know different things after 1970 that we did not know at the Article 32 proceedings, or that the military did not know at the military proceedings at the Article 32. Sometimes you have to change a story to keep up with where the evidence is going. He stated that the blood tests in the living room were suspect, but of course the benzodiazepine test, while it may give you a false positive, does not give you a false negative, and even John Thornton himself said that it was a very specific test for the identity of blood. They said, they gave you an explanation of why there was blood in Kristen's room and where the blood for the footprint could have come from. I think he said that the defendant could have carried it there, a weapon could have carried it there, or intruders could have carried it there. But the problem with that is that the only A-type blood there is in the footprint. It is not in a pool or something. It is not in a different location. It is in the footprint. If it is in the footprint, I submit to you that it is not rational to say that it got there through any of the three ways which the defendant alleged. Ladies and gentlemen, we talk about motive. What is the motive, again, for the intruders? I am not going to go back into that as I did this morning, but at the same time, you think about the motive for the defendant. While we aren't required to prove a motive, and he is not required to prove a motive, what is sauce for the goose is sauce for the gander. And if he says, "Where is your motive over here?" Well, okay. We will say, "Where is your motive over there?" I submit to you that when you compare them, ours is better. Ladies and gentlemen, They went at great lengths to discredit the pajama top, and I think that is deserved. Well, they should. I would too. Do you know why? Because it is mighty, mighty damning. Shirley Green did not say, as I recall her testimony, that she did follow Paul Stombaugh's theories on exit and entry wounds. She said that she didn't. There is a big difference between did and didn't. You recall the FBI report, and I mentioned it this morning, and I am sorry, but I have got to mention it again. Paul Stombaugh said that he saw several holes, not all as the defendant has correctly stated, that had the appearance of entry holes, and some that had the appearance of exit holes. He also concluded, a couple of paragraphs down, that because he got the pajama top a year and a half after the crime, it was impossible to determine whether or not the holes were entry or exit holes. I submit to you that their attack on the pajama top reconstruction is based on a false premise. They read you part of Stombaugh's testimony and tried to imply that he changed his story. You remember what he said? He said, "We refolded it exactly the same way." And they did. They put the left sleeve on the floor. They took the right sleeve and put it inside out. And they put it as best they could on a mannequin or something. Stombaugh never said, "We placed it in the same position." There is a big difference in the words placed and in the words refold. The fact that 48 thrusts or 21 thrusts through the pajama top can make 48 holes is a singular significant fact, which I tell you proves to me beyond a reasonable doubt that Jeffrey MacDonald killed his wife Colette, and it is a very short leap from that to say that he killed the other two as well. We have never said that the defendant faked his injuries. We are not contending that. I don't know whether he faked them or not. I don't know that there is any evidence that he faked them. We only tried to compare and contrast to you the injuries that his family received with the injuries which he received, and to tell you that they were not of the same consistency. The fibers at the end of the hall, there is no evidence in this case linking those fibers to the blue pajama top. Ladies and gentlemen, Mr. Siegel says that there is tremendous evidence of intruders, the ice pick, the 2 knives, and the club. He said that the club probably came from the well in the back of the house. You recall the testimony of Bob Shaw, who said that he looked for footprints in that area and didn't see any, but here we have got 4 intruders coming to the house perhaps without any weapons and finding them at the crime scene along with surgical gloves. Isn't that incredible, ladies and gentlemen? The people Milne saw, the person Micah saw. Helena Steckley doesn't even say that she had a weapon. Posey didn't say that Helena had a weapon. He said that there was something in her hands. Paring knives. Everybody who testified on this subject said the MacDonalds had knives. The ice pick. Pamela Kalin, I submit to you, is worthy of belief. You can recall her testimony. She changed her mind, true. She said that she was scared and frightened when she was first interviewed. She was 15 or 16 years of age. Mildred Kassab, who said that there was an ice pick. The defendant said that there wasn't an ice pick that he knew of. And the club, you recall the testimony of the defendant. He said that he had never seen that club before, and yet his attorney gets up here and says, well, it was probably there, and you can reasonably infer that, but it was only probably kept back here. Again, I submit to you that is the defendant seeking to have it both ways. Again, he says, how did those weapons get outside the back of the house, and it is implausible to throw them out? You know, a man who has killed his family can do a lot of things, I suppose, and I don't think it is too difficult to open a screen door and throw the weapons out the door. We submit to you that that is precisely what occurred. The girl that Mika saw doesn't fit their theory, not ours. Our case is not based on theory. Our case is based on fact. The girl had no boots. Milne. His story doesn't fit their theory as well as our case. But it fits our case perhaps better than it does their theory because it is quite possible that no one saw these people. It is also quite possible that the defendant saw them. What is the problem? It is that Milne saw them at 12 o'clock, and the description does not match the description the defendant gave of what they had on and what they were wearing. Finally, they go after Helena again. The only thing that I am going to say about Helena Steckley, because you can talk about wreaths, you can talk about going to the funeral, you can talk about wearing black, you can talk about killing a cat, you can talk about witchcraft, you can talk about anything you want to. But you can't overcome the one fact that the defendant, in 1970, at the Article 32, was shown her photograph and said that he had not seen her before. Now, how do you get around that? I think that takes care of her, of Helena Steckley. Finally, ladies and gentlemen, I want to say in closing, as we said this morning, that this is a difficult case, not because the evidence is difficult, but it is difficult because of the people involved, the Kassabs, who have been injured and will be injured for the rest of their lives, regardless of your verdict. Mrs. MacDonald, who has been injured and will be injured the rest of her life, regardless of your verdict. Their friends, who will suffer the same fate. And, I guess, the defendant himself. You know, I am sure it is very sad for everybody who knew these people to look at those photographs. I think it is very sad for people who knew these people to look at pictures of kids playing, of Halloween and Christmas. I wish more than you know that we could have shown you that kind of picture. I wish more than you know we weren't here. I wish more than you know that I did not think the evidence pointed to the defendant. I think the supreme tragedy in this whole thing really is, if our evidence is correct, and the defendant did it, which we believe he did, think for a moment of the last minutes of Colette, Kimberly, and Kristen, when they realized that they were going to die, and they realized for the first and the last time who it was that was going to make them die. It is incredible. It is unbelievable, as Wade said. You wouldn't think it. People have said that he is not that kind of guy, but, ladies and gentlemen, people do strange things, man's inhumanity to man. But we think he did it. For that, we are sorry. For that, you have an awesome burden and responsibility. You have got to decide, beginning tomorrow, what the evidence is and what your verdict will be. We believe strongly, as strongly as we don't want to believe, that he did it, and he is guilty of count 1 of first-degree murder, of count 2 of first-degree murder, and count 3 of first-degree murder. And I ask you to so find. Thank you.